through. But everyone went on and on and on. And everyone was saying, retire, retire, and write. So I retired. It's usually three, one paragraph. So through a letter dated 3rd November 2022 by Senior Principal Prosecution Counsel, Mrs. Vera Amolo Amisi, the Director of Public Prosecution seeks to have the present criminal case withdrawn against all the accused persons under Section 87A of the Criminal Procedure Code on the basis of an affidavit of support deposed by number 23-1077 Korea Obadia, a Senior Superintendent of Police and leading investigator in this matter. The affidavit in support of the application is dated 2nd November this year, and it was filed in court on the same day. In the subject affidavit, the investigating officer essentially relies on two grounds which are well articulated in paragraphs 5 and 6 of the document, being number 1, that the investigation team was given very strict and fixed timelines to come up with findings promptly, which made it very difficult to conduct thorough and comprehensive investigations into the allegations raised by the complainant. But secondly, that while investigations were still in progress, the Director of DCI, that is the Director of Criminal Investigations, Mr. George Kinoti, directed the investigating team to make recommendations that will enable the accused persons to face charges based on, and therefore based on immense pressure, the team made the recommendation. Now, Ms. Muriongi, for Director of Public Prosecution, buttressed the application by insisting that in spite of the office writing several letters to the investigating team, seeking evidence covering specific areas, they received no response. All accused persons, through their respective counsel, supported the prosecution's application to have the matter withdrawn under Section 87A of the Criminal Procedure Code. On cross-examination by Senior Counsel Kilukumi for the first accused, the investigating officer largely alluded to the contents of his affidavit dated 2nd November 2022. However, he indicated that the investigating team acted on the basis of a complaint from the Financial Reporting Center and that the matter was not politically instigated to harass and portray his client, that is, first accused is Honorable Rigathi Gachagua. We know him as, is it Rigiji? to the electorate as not being electorable. It is now common knowledge that first accused is the Deputy President of the Republic of Kenya, whereas again yesterday it also came to my knowledge that second accused is it current Senator Funyiri? That is Honorable Wahome Mwangi. I believe this is why the issue of political harassment has been taunted by the defense as the reason for the arrest of the accused persons. It will be repetitive for the court to delve into submissions of each individual counsel in respect to the instant applications, since they all associated themselves with the submission by Senior Counsel Kilukumi for the first accused. Essentially, they are of the view that first accused was the principal target in this matter, and the rest of accused persons are merely collateral damage, hence the entire proceedings amount to abuse of due process. Mr. Makoha, for the third accused, took the argument a notch higher by suggesting that the office of the DPP and DCI basically abdicated from their constitutional roles and urge the court to try and make recommendation to the effect that no charges should ever be preferred against anyone before investigations are concluded, and that there should be full disclosure of evidence before commencement of a criminal trial. In response, Ms. Muriungi for the state told the court that the office of the DPP relies on policy guidelines before the decision to charge is taken. The policy guidelines provide for 3 tests. I didn't know this. There's the evidential test, there's the public interest test, and the threshold test. In this matter, the DPP relied on the threshold test based on available evidence with the expectation of further evidence. With the expectation that further evidence will be availed before the hearing date. Counsel further added that under Section 54, under Section 5(4)(e) of the DPP Act, the DPP has the powers to review any criminal case. She was of the view that if A3 felt that his rights have been violated, he ought to have moved to the High Court, since this court allegedly lacks jurisdiction to entertain such. I differ on that issue, but again, won't delve in it, because instructed to proceed and operate within what was at hand. Definitely, administrative action will follow if they refused to comply. However, with the introduction of personal prosecutorial and investigative liability, such officers will be able to stand firm, unshaken, and resist the devil at all times. They would say, I'll face the sack. I mean, you can't push me to do what is wrong. I wind up by quoting what Lord Action once said: power tends to corrupt, and absolute power corrupts absolutely. It's a high time for all players in the justice system to embrace professionalism for the good of the nation. The law should never be applied selectively, but equally to all Kenyans. As investigators, prosecutors, judicial officers, we have a responsibility to clean this system or make it better. We never know, we may end up being subjected to the same process. Yet we have time now to change. Now, we have parliamentarians here. I think number 1 and 2, it's Wahome, you are here. Yeah, you should take up the initiative. Don't go there and bang how they clap. Come up with this legislation. Let us have
It's actually very, very unfortunate sitting here and listening to the judge say what ought to have been seen 3 years ago. It is unfortunate that this country has gotten to that extent where charges will be trampled up and opened against citizens in the full knowledge that the prosecution that they are charged are innocent and they are only meant to oppress people who have a different opinion. It is so unfortunate that this country has actually gone down where we were in the era of Moi. And we as the current government, we want to promise Kenyans that this will never happen again. The police will never be forced to use the judicial system to oppress Kenyans with different opinion. We'll never again use the judiciary system as a weapon to oppress those who are against our views. It is my desire as a parliamentarian that we actually bring law into place that will make people and officers who take such orders which are illegal from their seniors prosecutable, and actually because we have the Civil Service Act and we have the oath of office, it is illegal to be or to accept to be used in such a manner. Moving forward, We want to create a democratic space whereby the police can't do their work professionally, where Kenyans need not fear because they belong to a certain affiliation, and this will push and put the registration measures in place to make sure that moving forward, no other Kenyan will suffer what we have gone through the last 3 years. It is tormenting, it is traumatizing for our families, it is dehumanizing for our business, it has ruined us, and we are actually, as we stand today, could not go to any bank and access any finances because